Hi there, contract student, and welcome back to our second lesson on contract interpretation. If you want to follow along at home with notes, illustrations, and examples, you can get a copy of my contract interpretation slide book at the link below. Today we're on slides 53 to 83, and I really recommend using that because today's lecture is really just going to go over a lot of material quickly. You might find it useful to reference some of the material in there or in the casebook, page 522 to 560. In the first lesson, I introduced the overall methodology of contract interpretation. In this second lesson, I discussed the first step in contract interpretation, which is interpreting express terms using the canons of construction. So what are these canons of construction? That's going to be the subject of this video. Express terms are our source of intrinsic meaning, which is generally regarded as the best evidence of parties' intent. But contract terms are not always clear. Contracts can have ambiguities and inconsistencies within their four corners. Fortunately, we have canons of construction, which are a set of generally agreed upon rules and principles about how to disambiguify contract terms. Since the canons are generally agreed upon, we can use them to predict how a court might interpret an ambiguous term. While scholars might disagree on exactly how many rules constitute all of the canons of construction, for the sake of this video and my class lessons, I identify 13, which seem to be generally accepted. The 13 canons are as follows. 1. Use the ordinary meaning. When the language of a contract is plain and unambiguous, courts should give effect to the contract as it's written, without engaging in elaborate contractual interpretation. The literal words of a contract are presumptively intended to convey their plain, usual, and ordinary meaning, and so parties are expected to use their ordinary terms in their ordinary way. As a result, courts will use dictionaries and other such devices to determine the ordinary or plain meaning of the word, and this is also called the plain meaning rule. Number 2, use technical meaning. Technical terms and words of art are given a technical meaning when used in a transaction of that technical field. When both parties to a contract are members of the same technical field, technical words they use in their contracts with each other are presumed to have that technical meaning. Now, technical meaning does not apply when only one or neither of the parties is in the technical field, because you wouldn't expect the parties to both be using that meaning. 3. Interpret the writing as a whole. All writings that are part of the same transaction are interpreted together. This rule is predicated on concepts of textual integrity, and it necessarily leads to other rules that would avoid rendering any provision of a contract superfluous or unnecessary. Rule number 4 is give force to every term. An interpretation is preferred that gives force to every term and provision of the contract and does not create any irreconcilable conflict between provisions. Number 5 is that we preference specific terms over general ones. Specific terms and exact terms are given greater weight than general language because we assume that parties gave more thought when they drafted specific terms as opposed to generic general ones. Number 6, interpret words consistently. When the same word is used in different parts of the contract, it'll be presumed to have the same meaning. We presume that parties use the same word in the same sense throughout the contract. As I tell my students, it's not the time to pick up a thesaurus. 7, interpret words in context. Words derive meaning from the words with which they are associated. This is a rule of linguistic inference, which presumes that a general term is similar to more specific terms in the same series or list. Number 8, specific terms limit general lists. General lists derive meaning from the specific terms that precede them. Similar to Canon 7, this is a linguistic inference that presumes a general term reflects the class of objects in which it is listed. So if there's a list and we can sort of categorize that list, we want to identify that general term as being part of that category. 9. Added terms are preferred over boilerplate. Separately negotiated or added terms get greater weight than standardized boilerplate terms or terms that were not negotiated. Similarly, terms handwritten on a form are generally given greater weight than standard terms in the printed form. 10. Expression of one implies exclusion of the other. When some things are specified in detail in a contract, other things of the same character are excluded by implication. Number 11. Avoid illegality. If a contractual provision is susceptible of two reasonable constructions, only one that comports with the law is the one the court should choose. The court should choose an interpretation that makes the provision legally enforceable. We want contracts to be enforceable. 12. Follow the rules of grammar. The semantic meaning of terms arises from the rules of syntax or grammar of the language they belong to. Words are best understood in their grammatical context as well. And 13. The last antecedent rule. A modifying phrase at the end of a list is understood as referring only to the last item of that list, unless there's a specific reason to understand the phrase as applying to all of the items in the list. These 13 canons are rules, and you can use them to determine the semantic meaning of an ambiguous term and to predict how courts would do the same. Now, applying them is a very fact-specific process. Let me give you an example. Consider a home insurance contract that said pollutants aren't covered. Well, lots of things can happen in a home. What about overabundance of carbon dioxide, or dispersal of lead paint chips, or bat guano? Are those pollutants, are they covered? This exercise will demonstrate how often you need to use several canons to disambiguify an ambiguous term, and it will illustrate parties can often make strong arguments on both sides. In addition to these 13 semantic canons, there is also a policy canon, which you can call Canon 14. Canon 14 is construction against the drafter. If all of the other canons should fail, as a last resort, the court may resolve the conflict by construing the ambiguous term in favor of the non-drafter when that party lacked bargaining power. Although this rule eschews semantic meaning, it's justified by its mitigation of the perceived unfairness in the bargaining process between parties of greatly asymmetric power. And it does have the pragmatic reason of encouraging drafters to be clearer in their language. Up next, we will learn about the objective and subjective theories of contract interpretation, and we'll discuss whether contract interpretation is a matter of fact or a matter of law, which matters for appellate review. Thanks for tuning in. I'll see you next time. Right, boy? Come here. Yeah, buddy. Say hi. Okay. What?